is an advertising fee to this station.
This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight it's Ask Us Anything night, so call in your questions on anything from car accidents to domestic relations cases, child support, custody, medical malpractice issues, anything, whether big or small, call in and ask. You can be live on the air, 256-536-0077. But if you're too shy to be live on the air, you can also text us to that same number, and we've got some of your text questions coming in tonight. You can also email any question any day of the week to lawcall@waytv.com, and when we get to a show that's on point, we pull some out. We've got some of your email questions tonight. We've also got Michael Timberlake from Timberlake, League & Brooks. Good to have you here.
It's great to be here.
Personal injury cases are what you guys do. That includes
what
all kinds of areas?
Well, the most common personal injury case that you'll see is a car accident, because
Okay.
those are the most typical ways that people can be injured. But you also see, injuries at stores, at businesses. You see injuries on the job, construction sites. You see, medical negligence claims, products liability claims, where people are using a product that was defective and has injured them. It's across the board kind of what we do and what we see.
And we've been doing this show for a very long time.
30 years.
30 years of Law Call, answering your questions live on the air. We actually have some footage of, there's all kinds of lawyer jokes. Apparently Michael told us something funny in 2006. Let's take a look.
Uh-oh.
Okay, they're going to get it to us in just a second.
Right.
Now we've got you on pins and needles.
Yeah,
don't we?
now I'm kind of worried about this.
I don't know what
we built it up.
I bet
better be good.
The punchline ended in skid marks. All
Sure.
lawyer jokes end in skid marks. We got this email question in from Dan. Dan had said, I just bought some acreage in Morgan County. My neighbor's been walking and hunting through those woods for 40 plus years. I don't want to be a don't step over the property line kind of guy, but is there something that I can do to gently ensure I'm not liable if he gets hurt on my land? So that's pretty gracious of him to be willing to let this person continue to come on. Is he in trouble if somebody gets hurt?
Well, if he's allowing the person to come on, so he's not a trespasser on the property, so he's giving him permission to come on the property, then the landowner only has an obligation to warn him about duties that they're, about hazards or defects that he's aware of, that he knows of. But in a situation like this, just to be safe, you can ask him to sign a pre-injury release or a waiver. They're valid for adults. They're not valid for kids. So the ones you signed at the trampoline park are not valid. But in this situation, two adults could enter into a pre-injury waiver. Basically says that, in exchange for access to this property, then, you're not going to hold him responsible for any injuries that occur on the property.
Okay, so back up to this thing with like trampoline parks and kids.
Sure.
Or water parks and
Right,
kids,
absolutely.
or anything that parents sign.
Right.
You're saying that doesn't hold water?
It doesn't, because the children are minors. They're not able to contract. And simply because you're a parent doesn't mean that you can waive your child's rights if they were injured as a result of somebody else's negligence or something on their property. So the parents will sign them, and a lot of times they don't think they can do anything when a child is injured. But in most situations, they're not valid, and the child is able to make a claim, or the parent is able to make a claim on behalf of the child.
So why do those places keeps having you sign those waivers?
I think because they think it's a deterrent.
Okay.
It's basically the parents say, well, I signed that thing.
Okay, if you think you can't, maybe you won't.
Yeah, exactly.
Okay,
And so we explain that to a lot of people over the years.
Okay. We got in a text question. This one says, is it possible for your employer to fire you while you're out on medical? So I don't know if that's just medical injury, or if that's medical leave, or if that's workers' comp related.
Yeah, so there's kind of 2 or 3 different ways you can look at this. One is if your employer has over 50 employees, then they're bound by the federal by the medical, they're bound by the Family Medical Leave Act, which says that if you have a family medical emergency, or you have an emergency of your own, then there's a certain period of time, 6 weeks, where you can request leave from your job, unpaid leave, but they have to hold your job for you. So if it's a personal problem, you can get family medical leave. If it's a workers' compensation claim, your employer cannot fire you while you're out on getting paid for an injury.
Injury on the job.
Injury on the job.
Okay. We've got questions, callers in. We've got Dewan on the line from Decatur. Hi, Dewan. Thanks for calling in. What's your question tonight?
Hello.
Hi.
Yes, I was wanting to know, what can I do about last year on Memorial Day, an escaped inmate escaped out of police custody, came upon my property, went to my doggy door, hid upon my porch, and the police came behind him. They commenced to kicking in my door, and while the other people or other officers were in my yard, they broke my dog's jaws. They killed a little puppy. So I wanted to know, what can I do?
Oh my goodness.
Oh, goodness.
Well, yeah, that's a terribly bad situation. You know, if you're dealing with state employees, police officers, if it's a sheriff's department, they have broad immunity for what they do while in the line and scope of their employment with the state. So unfortunately, the legislature has seen fit to give them immunity basically for a lot of their actions. We see it a lot of times when like a sheriff deputy rear-ends somebody.
Like they're chasing somebody or something happens?
Not even if they're chasing somebody. They're just
do
on the job and they're in a wreck, they're immune. So they're not obligated to pay anything for their injuries. So it's a bad situation. Not sure that you'd have any luck recovering from the state.
Okay, good luck, Dewan. We got in this text question. Somebody's asking, is the insurance company supposed to continue to pay the medical bills after a person is hit by a vehicle? Okay, what amount of medical bills does the insurance company have to pay?
Right. So basically, if it's a liability situation, you're trying to collect from another party who is at fault. Liability claims, it's not a pay-as-you-go situation. The liability carrier will pay a lump sum amount once your treatment is completed to resolve your claim. You'll sign a release and your claim will be over. Once you do that, there's no other compensation you can get. The release is final and the case has gone away. In situations where you are making a claim for an injury that occurred, for the cost of an injury that occurred in a motor vehicle wreck against your own carrier, you can collect for medical payments coverage if you have that coverage. Typically, it's $1,000 to $5,000 that you have on your own policy to pay for medical treatment as a result of an incident or a wreck.
So other than that, how are you supposed to pay for your medical bills until the insurance pays off?
You can pay, if you have health insurance,
they'll pay.
Or Medicaid, Medicare, they will typically pay for the injuries that you suffered in a motor vehicle wreck for the cost of the treatment. And then once you recover, you have an obligation to pay them back what they paid out of the recovery. It's a right of reimbursement or subrogation is what we call it.
And if you don't have insurance?
If you don't have insurance,
then up with it yourself?
You've got to figure out a way to either come up with it yourself, or there's some providers out there who will work with people in that situation and understand that if it is if the person is not at fault and we're working with them to try to collect, sometimes they will treat people and then get compensated after when the case resolves.
Okay. We're going to take a quick break. We'll be right back answering more of your questions. It's Ask Us Anything night.
League and Brooks, which pays an advertising fee to this station.
You're watching WAAY 31 Law Call, the Tennessee Valley's only live legal call-in show for 30 years and counting. Presented by the award-winning personal injury and wrongful death law firm Timberlake, League and Brooks, featuring the knowledge and experience of attorney Michael Timberlake, attorney Will League, attorney Heath Brooks, attorney William Meservey, attorney Bobby Marsh, and hosted by family law attorney Sharon Doviet. Your rights, your calls, live. This is WAAY 31 Law Call.
Welcome back. We are celebrating 30 years, and there's been some funny moments over the years. Check out this clip of Michael back in 2006.
You know, we've had a number of them and had some good luck with them, but, you know, I had one of the cases I took in, a lady called me and said, oh, I'm hurt. I fell in a store, and I was like, oh my gosh, I can't believe you're that badly injured. I said, what did you fall over? And she said, this big wet floor sign.
That's exactly what you'd fall over. You look exactly the same.
Well, I mean, you know, a little different. You know, time is undefeated. I'll tell you that much. But that I specifically remember that case.
Yeah.
Because, well, we got the video from the store owner, and she just walked right into the big sign that said "What floor?" Oops.
That happens a lot, though, doesn't it? People walk right into whatever obstacles you put up.
Yep.
Yeah. We've got callers waiting. We've got Rick on the line with a question from Cortland, Alabama. Hi, Rick. Thanks for waiting. What's your question tonight?
Hello. Thanks for having me.
You're very welcome.
I'm in the process of buying a mobile home. They don't have any title. It's a 1988 model. Can we do this with just a bill of sales?
Do you know, with mobile homes and titles, I thought they had...
You know,
they had something.
I think is a mobile home. Is it a?
I thought it was like a vehicle, but maybe not. No,
well, I was going to say it's not real estate, so you would have to have some kind of title. I think the question is you could do it with a bill of sale, but then the question becomes, you know, if you pay money for something and you don't have title to it. So if it's one of those things they don't have the title to it, then they have to get a replacement title from the state. And then that would allow you to purchase it. So you know, if you're the purchaser, I wouldn't want to pay money for something with just a bill of sale. You can transfer it, you can, but then the question is, you know, does the other person really have good title to it? And if you're going to try to sell it, somebody's going to want title from you at some point. Yeah.
We got a text question in. I'm a renter in Franklin County, Alabama, and I was wondering what I should do if my landlord won't fix anything in my trailer, but it won't. But also won't make it rent to own.
Yeah, I mean, I don't think there's anything you can do to make them make it rent to own. But if your landlord, if you've got a lease and your landlord is not living by the lease, and the Landlord-Tenant Act in Alabama basically gives you the right to break the lease, move out, and don't have to pay. You don't have to honor the remainder of the lease. But that's really kind of the remedy you've got if they are not doing what they're supposed to do.
Somebody texting in saying they've got a child who's now 19. He doesn't respond to gentle guidance. And they want to, what 19-year-old does.
Yeah, exactly.
They want him to move out and be a grown-up. Do they have to give him a 30-day notice to evict him? And is there any kind of continuing obligation to provide food and necessities outside of the tenancy over age 19? Nope, in Alabama, 19 is it.
19 is it. You're of the age of majority. They're not responsible for you anymore legally. You know what you're going to do for your kid to make sure that they're healthy is a different thing. But in terms of someone that's living in your home, the safe way to do it is go through an eviction process, which is 14 days notice, and then they get another 14 days to move out.
We got in an email question from Martin. Martin says, I was a passenger in a wreck, and I got a diagnosis of spinal ligament sprain. Both drivers' insurance companies have called about the injury, but I haven't called them back yet. Is there anything I need to be watching out for when I call them back?
Yes.
Yes.
Yes. You know, there's no need to talk to an insurance company without talking to a lawyer first. You don't have to hire a lawyer. Firms that do what we do initial consultations for free. We do phone consultations all the time in situations like this, and basically tell people what their rights are, what their responsibilities are, what to expect from the insurance company. And if it's a case with a minor injury, then and somebody understands what they need to do, they can sometimes resolve it on their own. If not, then we can get back involved. But in a situation like this, if you haven't been through, if you're not a lawyer, you don't handle automobile accidents, get some advice. Know what your rights, know what's going on before you start talking to insurance companies, because they'll listen to you, and if they can use something you say against you, they will.
What would they use against you?
Oh, well, I saw that car coming before it hit me.
Okay.
So then automatically, if you saw it coming, you could get out of the way.
Okay.
You didn't get out of the way.
Oh, and now you've stepped in it, haven't
Yes,
you?
yes,
Okay.
yes.
You're talking about personal injury attorneys will normally walk you through a little bit of this for free. Okay, when you take on a case though, how does the attorney get paid? Because a lot of people don't have the money to hire an attorney for a big case.
Right. Injury attorneys take claims on on a contingency fee basis, which basically means we only get paid if and when we collect in a case. So we advance the cost of pursuing the claims. Cost of medical records, cost of investigation, cost of trials, depositions, litigation if it gets that far, and then we're reimbursed depending upon the type of case and the expertise involved. It can be somewhere, workers' compensation, you're limited to 15% by statute. Typically, car wrecks are on a third of the amount collected. More complicated cases, products liability, med mal, can be 40, 45, 50% of the amount collected, simply because of the risk and the expertise necessary to take on those cases. But it's really, in all these situations, there's no money out of the pocket of the person that's injured until there is a recovery.
Talk a little bit about medical malpractice cases. So those are difficult to win usually, right? Because people think I was given the wrong medication, or my surgery didn't turn out just perfectly. Don't I have a case? Isn't this going to be valuable to me?
Right.
Talk a little bit about medical malpractice cases.
So there's no warranty for medical care. The Alabama claims are governed by the Alabama Medical Liability Act, and basically what it says is that if you want to pursue a claim against a doctor, hospital, nurse, whatever, you have to prove that they did something that no reasonable person in the same situation would do. They violated what we call the standard of care, and they did something that was unreasonable for that medical profession. You also have to prove that what they did directly caused an injury. Proving a violation of the standard of care turns out to be very difficult in a lot of situations, because things can happen in medical care. There are no guarantees that there's going to be a particular result, and simply because there was a complication of a procedure, or it didn't turn out the way everybody wanted it to, or things didn't go right, that doesn't automatically mean that the healthcare provider did something wrong. You got to prove that they did something that was unreasonable that led to that result, and that can be very tricky.
What are you wanting people to bring to you when if they are considering a medical malpractice case?
Sure.
What do they need to bring to you to talk about?
Before I can really even talk to somebody in a medical situation, we need the medical records from the medical providers, because that's basically gives us a roadmap of what the defense could be. Now, there's a lot of information that we can get from people that were injured or believe they've had medical injuries, but we need the documentation in the medical record to kind of determine what's going to happen, what's going to go on, what were the pre-existing conditions, what was the problem that was being treated, what was the course of treatment, what procedures were done, what techniques were used. Those are all the kind of things that we need to basically, before we can tell anybody, hey, there's something here, or there's possibly something here, or there's definitely not anything here.
Worth getting the medical records, paying for them?
Sure.
Okay.
Yeah, and most medical rights, after the Affordable Care Act, that most medical records can be obtained by the patient electronically for $6.50.
Okay. Somebody's writing in and says, why will no one in Huntsville represent federal workman comp cases? Does anybody take, is that an issue? Have you?
Well, there's federal workers' compensation cases are a bit of a niche. That's a small number of people are gonna have them, and there's a lot of expertise that's required. Our firm, if you have one of these and you want a referral, we have a firm that I've worked with in Atlanta that does a lot of them, and a firm in DC that does them. And they can be done, they're not state specific. It's based on federal law, so you don't need an Alabama attorney. And if you need to go through a local attorney, we can do some of the local legwork for these lawyers. But in general, you're looking at a bigger city that has a larger population that has potential for more of these cases to allow the firms to survive.
Gotcha. Somebody texted in a question. I'm being sued for $2,400 in small claims court. I'm on disability and I'm having a hard time making ends meet. I don't have any property that's valuable. Can they take my car, or should I file bankruptcy to prevent them from being able to do that?
For $2,400, you're probably better off contacting the opposing party and seeing if there's some kind of payment plan you can work out. You can, if you agree to a consent judgment in that situation, then you can make, you can work out some kind of payment plan where you're going to pay off the judgment. Bankruptcy for over $2,400 really doesn't make a lot of sense. If you own any real property, you could lose it in the bankruptcy. Typically, a bankruptcy will allow you to keep your car, but again, that's a big process. That's probably not anything you want to go through. And if you can't pay $2,400, tell them, look, I can pay $1,500 over 15 months, $100 a month, and see if they're willing to take it.
Good. You were talking before about the federal workers' comp case.
Sure.
And attorney in, say, Atlanta.
Right.
How many times are people really needing to meet with an attorney? Like, is there somebody going to have to go to Atlanta to meet with that person, or to hire you guys?
Sure,
if they're injured and they can't get to your office, how does this work?
Yeah, I mean, it's a kind of a case-by-case situation. We will still go out to we'll go to the hospital, we'll go to people's houses, we'll go, meet people in the McDonald's somewhere, if it's if that's a convenient place. But we typically like to have face-to-face meetings with our clients, and we typically do those in our office. But it's not absolutely necessary, and the technology that was advanced in the pandemic, through Zoom and through FaceTime calls or whatever has been really beneficial when you just can't get there to meet with somebody. And so that's typically what we do. Firms like this would be able to handle a claim, they could basically handle it electronically through the forms that they need and get that information. And then, like I said, if they need a local attorney, they'll figure out a way to make that happen.
Gotcha. Let's take a break. Be right back answering more of your questions tonight.
which pays an advertising fee to this station.
If you didn't get your questions answered tonight, here's how to get in touch with Michael Timberlake with Timberlake, League & Brooks in Huntsville, 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And Sharon practices family law right here in the Tennessee Valley. She does divorce, child custody, custody modifications, those types of things. 256-539-7337 at SharonFamilyLaw.com.
Let's talk about statutes of limitation. So how long do you have when you've been in a car accident or various things to file something?
Typically, you have 2 years from the date of the injury in order to file a claim in the court, not make a claim with the insurance company, file something in the courthouse to prove your claim. If you're a minor, you have 2 days from your 19th birthday to make the claim.
2 days or 2 years?
2 years.
Okay.
I say 2 days?
Maybe.
You have 2 years from your 19th birthday to file a claim. So you've got an extended period of time if you're a minor.
Good. Thanks for all your calls and questions, and we'll see you next week.